Well, my name is David Willis. I'm an attorney in Brownsville, Texas. That's where I'm born and raised, and that's where my office is. I've been taking Tmpa cases for 12 years. My area that I primarily work in is from Brownsville. It goes up to Laredo. I've done some cases in Del Rio. It goes back across toward Alice and then to the Corpus area. I started off taking these cases through a recommendation from a colleague who was going to go do TML work. I started off just taking 1 or 2 cases, and over time the volume of cases grew, and it's something that I've really come to enjoy and be proud to do. The work that I am privileged to do is exceptionally important. Down here where we're at, we have a lot of political influence that weighs heavily on our officers who are just trying to enforce the law. And a lot of times they feel the brunt of political winds, and they need protection. They need people to defend them, and that's something I'm very happy and really think it's important to do. A good number of the cases that I deal with I'll call unforced errors. That's when the officer brings a personal problem into the department, relationships outside of work, social media posts, and drinking. Those things get to be real big problems. And that's something that I've had to unfortunately deal with more than I would like to. Honesty is the number one instruction that I give to my clients. It's my opinion that unless there's an absolute egregious level of misconduct, an officer can get through it so long as he's truthful about it. If there's any sort of indication that the officer is exhibiting a lack of candor or even just being slightly untruthful, it makes my job so much more difficult, because then you're getting into the realm of insubordination, and they've taken a small problem or a medium-sized problem and you've made it into a gigantic problem. And hearing examiners and civil service commissions do not look favorably on an officer who's accused of being untruthful. An officer who's involved in a critical incident is usually pumped up full of adrenaline and is extremely worried about some consequences, especially if it is their first time, which it is for most of them. And at that point, they don't really have a vivid recollection or an accurate account of what really happened. And if they start talking to other officers, friends in the department, superiors that they're just wanting to ask questions, hey, what happened? Well, what they don't really realize is that person that they're talking to becomes a witness. And they become a witness in a possible inconsistent statement. And that is where we get back into the idea of a lack of candor or untruthfulness. At that point there, when a reviewing grand jury is looking at it and they see that this officer had an inconsistent statement, he said one thing at the very beginning and then all of a sudden he gets an attorney and he says something else, even though the second statement could be completely accurate. It could be a real problem for that officer in front of a grand jury. Fortunately, this is something that I really have a passion for doing. We've been able to, over time, I think, gain enough experience and professionalism to be able to make sure that all those needs can be met. If I have a setting in McAllen, I got to go up to Corpus, I've been able to develop a rapport with most agencies over time where I can get some additional time if necessary. We also know how to handle officers if they're in a drop-dead emergency situation, handle some emergency things over the phone until I can get there. What you've got to remember is that law enforcement officers out in the field face lethal consequences on a daily basis. They put their lives at risk every time they go out. And sometimes they're dealing with elements of the population who literally want to hurt them. And in circumstances where they have to use force, everything is magnified. And like I said earlier, the officer's recollection at that particular moment in time is subject to misremembering because of adrenaline and other factors that go on in a flight or fight situation. A lawyer is there, number one, to protect that officer from making statements that are incorrect. He hadn't had the opportunity to review his body cam footage or any of the other evidence in the file, and he's basically making statements on emotion that could be problematic for himself on a criminal liability situation, and it could also be problematic for his employer in case there's any sort of civil rights claim, and they say, you made these statements early on and those turned out to be incorrect and you don't really know exactly what happened that day. Those kind of things that could be a real problem for a city. My most emphatic instruction to any client that I'm talking to on the phone while I'm saying I'm on my way over there is you need to be firm but respectful and say, on advice of counsel, I'm not going to answer your questions at this time. I think that kind of statement avoids a charge of insubordination. I think it notifies the department that the instruction is not coming from the officer, but it's coming from the attorney. And also at the same time, it gives that officer some time to decompress and lose those emotions. You know, officers do have a Fifth Amendment right against self-incrimination. And it is important that they exercise that right. I fortunately have had the grace to have represented officers who've each time have been found to have used force in a justified manner. It's governed by Chapter 9 of the Texas Penal Code, and each of my officers have been successful in their own defenses that way. But what needs to be remembered is that in that particular setting, they can try to compel an officer to make a statement, but they have the Fifth Amendment. Now, in the administrative setting, that's something far different. In the administrative setting, when a department head comes in and says, you need to answer the questions on the following things, he does have to give you what they call a Garrity warning. And a Garrity warning is nothing more than a rule of evidence. It is a prophylactic rule that says that because an officer is being compelled under the threat of losing his job to make a statement, that is a compelled statement. And so anytime that officer makes a statement under that particular set of circumstances, it cannot be used in a criminal trial against that officer, save and except for the limited circumstance of inconsistent statements. It can be used for impeachment. So for example, an officer is in an administrative investigation. They're asking about his use of force. He testifies to one version of events. The criminal trial against that officer proceeds in a different venue, and for whatever reason that officer decides to take the stand. And he describes a set of circumstances that were different than what he talked about in the administrative case. In that limited circumstance, that statement he made in the administrative investigation can be used against him for impeachment purposes. So you got to be careful. And that's exactly why that there is an Attorney General opinion granting officers the right to not only review their body cam, but any other footage around that particular incident, because they need to be able to speak truthfully, free of the influence of their emotions and their bodily chemicals. And so that's the reason why we take these things very slowly and deliberately. Any statement that a law enforcement officer makes to a criminal investigation division, the Texas Rangers, anybody like that, is voluntary. And so you control the timing, you control when it happens, you control the content and the amount of the statement itself. It's all within the officer's control, and you want to make sure that it's done clearly and accurately.